Welcome, students! Today, we're going to master the exact framework you need to score maximum marks on a very critical KSLU constitutional law exam question. Listen, when you see a prompt like, write a note on schedules and review of working of the Constitution, you absolutely must not panic, right? Instead, you must be methodical. We're going to apply a rigorous, purely text-based approach today to help you structure your answer perfectly. Let's get straight into it. Students, take out your pens right now. I want you to write this exact synopsis on your very first page. 1. Introduction and definitions. 2. The 12 schedules. 3. Need for review. 4. NCRWC recommendations. 5. Landmark case laws. And finally, 6. Conclusion. Setting this up tells the KSLU evaluator you have absolute command over the subject before they even reach your first paragraph. Moving on. Okay. We'll start with your first bold underlined heading of your answer script. Part 1, Introduction and Definitions. Now, record this definition exactly as it appears. Schedules are appendices to the Constitution, containing supplementary details such as lists, forms, and provisions. Now, make sure you strongly underline the jump from originally 8 schedules to now 12 schedules. Why? Because evaluators are actively looking for this historical awareness, you see. It shows them you understand our Constitution is a living document that has expanded to accommodate our massive republic.
Right, moving to Section 2, the 12 schedules.
We are going to march rigorously through these statutory provisions. You literally cannot skip a single one if you want that perfect 16-mark score. Read and write this precise text verbatim into your notes. First schedule, names of states and union territories. Second schedule, salaries and allowances of the president, governors, judges, and so on. Third schedule, forms of oaths and affirmations. Fourth schedule, allocation of seats in the Rajya Sabha. Memorizing these first 4 sets the absolute structural foundation of your answer. Keep your bullet points unmerged and crystal clear, okay? Moving to the next block, we have the 5th schedule, Administration of Scheduled Areas and Tribes. 6th schedule, Tribal Areas. Now, pay close attention here. Ensure you explicitly write Assam, Meghalaya, etc. for the 6th schedule because examiners scan specifically for those keywords to differentiate it from the 5th. Then, for the 7th schedule, Division of Powers. But don't just write Division of Powers. You must explicitly list the union, state, and concurrent lists. Finally, the 8th schedule, Recognized Languages, and note in brackets, currently 22. Precision is absolutely key here, students. Next, the vital additions. 9th schedule, Laws Protected from Judicial Review. 10th schedule, Anti-Defection Law. 11th schedule, Powers of Panchayats. 12th schedule, Powers of Municipalities. Now, after copying this exactly, you must heavily underline the 73rd and 74th amendments right next to the 11th and 12th schedules. Highlighting these specific constitutional amendments is a real game changer. It practically guarantees you those extra marks. Okay, start a fresh paragraph on your script. New underlined heading, to shift our focus. Part 2, Review of Working of the Constitution. Under this heading, you need to establish exactly why we even review the Constitution in the first place. State these 3 points distinctly. 1. To assess the effectiveness of constitutional provisions. 2. To meet changing socio-political conditions. And 3. To improve governance and accountability. Stating these plainly establishes the theoretical foundation for why constitutional review mechanisms are absolutely necessary in Indian jurisprudence. Now, we bring in the empirical evidence. You absolutely must cite the National Commission to Review the Working of the Constitution, or the NCRW, established in 2000 under M.N. Venkatallaya. Students, listen to me. If you do not draw a box around the year 2000 and the name M.N. Venkatallaya on your paper, the evaluator will deduct marks. Former Chief Justice Venkattallaya's leadership here is a non-negotiable fact for a complete answer. Let's dissect the exact outputs of this commission. Heading: NCRWC Key Recommendations. You're going to write these exact recommendations in clean, unmerged bullet points. Strengthening fundamental rights, electoral reforms, judicial reforms, decentralization of power, good governance, and transparency. By listing these out so cleanly, you show the examiner that you haven't just memorized the name of the commission, but you actually comprehend the substantive legal reforms they proposed. Before we move to the clincher, note this vital principle perfectly. The importance of review is that it ensures the dynamic nature of the Constitution, helps remove defects, and strengthens democracy. You see, a static law is a dead law. Writing this statement proves to the evaluator that you truly grasp the underlying philosophy of constitutional law. All right, students, pay maximum attention right now. Section 5, Landmark Case Laws.
This is the mandatory judicial interpretation segment. Without a deep case law breakdown, your paper is fundamentally incomplete, okay? The first case, Kesavananda Bharati v. State of Kerala. Write this exact citation in a separate boxed format to immediately capture the evaluator's attention for 10-mark or 16-mark answer. But don't just drop the name, we have to elaborate on the details. I'm pausing here because we need to dissect this thoroughly. You must clearly separate the facts, the ratio decidendi, and the relevance. Write it exactly like this. Facts. There was a massive challenge to several constitutional amendments regarding property rights and Parliament's amending power. Ratio decidendi. The Supreme Court held that while Parliament has vast powers to amend the Constitution under Article 368, it cannot alter or destroy its basic structure. Now, what's the relevance? Why does this matter? Well, it established the basic structure doctrine, fundamentally limiting the absolute power of the legislature. In simple terms, you can review and amend the Constitution, but you absolutely cannot break its foundational pillars. This is the very bedrock of our constitutional stability. Now, for the second landmark case, I want you to double underline this mandatory case name in your answer booklet, I.R. Koel v. State of Tamil Nadu. This case perfectly bridges the concepts of schedules and judicial review. Let's break it down. Facts. The case dealt with laws specifically placed under the 9th schedule to protect them from being challenged in court. Ratio decidendi, the Supreme Court decisively ruled that placing a law in the 9th schedule does not provide blanket immunity. Laws placed there after April 24, 1973 are absolutely subject to judicial review if they violate the basic structure. The relevance, such laws can and will be struck down. By connecting the 9th schedule back to the basic structure doctrine, you show the KSELU examiner a masterful conceptual grasp of how these constitutional provisions interconnect. Finally, we tie this entire legal concept together into a cohesive concluding remark. Section 6, Conclusion. Never, ever end a law essay abruptly. Memorize this exact sentence and write it verbatim at the very end of your script to leave a flawless final impression. The schedules provide structural clarity to the Constitution, while periodic reviews ensure its effective functioning. It's concise, it's powerful, and it perfectly summarizes the entire thesis of your answer. You need to explain to the examiner that Indian constitutional governance is a delicate, intricate balance between these two exact concepts. On one side, the schedules provide the necessary structural clarity and stability, literally the fixed rules of the game. On the other side, periodic reviews, commissions like the NCRWC, and judicial oversight ensure adaptability and effective functioning. Together, they maintain the equilibrium of our entire republic. So I leave you with this pivotal question to ensure your exam preparation is completely foolproof. Have you structured your answer to seamlessly integrate the strict statutory schedules with the dynamic judicial interpretations? If you follow the exact text, the headings, and the rigorous case law breakdowns we cover today, your answer will be legally unassailable. Study hard, maintain that high contrast clarity in your writing, and structure your answers flawlessly. Best of luck, students.